No, it's definitely a good ruling. It's actually a good ruling with respect to our appeal in Kari Lake's election contest, because what the court focused on was the plain meaning of material terms in the statute. And so in this case, it was what constitutes the registration record. And the statute says, you look at signatures that are on the registration record, not anywhere else, which is where Secretary Fontes was pulling signatures from, whether it was from DMV or some other location. So what the court said is, under established law, the plain meaning of registration record is very obvious. And if you're looking at signatures outside of that registration record, that's the form that voters fill out with their signature, then you're violating the law. And so, for example, in our appeal of Kari Lake's, the signature verification requirement requires the voter's signature on the ballot envelope to be, quote, compared to the record signature. And we had the electronic logs show that signature verification workers were verified over 70,000 signatures at less than 2 seconds a signature. That's like a flash. And so the issue there is, what does the word compare? Well, Maricopa has training. The Secretary of State has training how to compare signatures. And as our expert Eric Spakeen testified, you can't compare two signatures in less than 2 seconds a signature. And they did over 70,000 of those. They did over 276,000 in less than 3 seconds a signature. And so that claim, just like the court in Yavapai, turns on what is the how do you look at the plain meaning of material terms in the statute. So that's a very good decision on that score for everyone, but also for other cases like this one. And there's also another case pending by Kari, as well as We the People Arizona Alliance, to get the ballot envelopes from 2022, so that the actual envelopes, so that the signatures can be compared. You recall that Shelby Bush of We the People Arizona Alliance did a presentation to the Arizona Senate in January, and they found, I think it was something like about 17% of signatures did not match from the 2020 data, and they had the actual data that was used to compare signatures in 2020. And so 17% out of 1.9 million ballots that's a huge number.
Absolutely.
Of ballots that, if they're not cured, would be illegal. And so we're now seeking the ballot envelopes for 2022.
How do you know they still exist?
Well, they better, because under federal records retention law, as well as Arizona, they should have been preserved. And so if they don't exist, there's potentially even a bigger problem. But I think they do exist. And that decision defines where what the signature is and whether or not that is confidential data that can't be released. And it's very good for us in our argument that those records are not confidential and should be released.
Wow.
Again, this gets into the whole issue of transparency. I mean, every time you look, whether it's to look inside the machines, to get log files within the machines, to get voter signatures, how on earth can a ballot envelope with a signature on it, which is put in the mail system for everybody who's touching it to see, how could that be considered private information? Yeah. Yet that is what Maricopa has been arguing. So this gets to the larger issue of transparency and compliance with the law. And so the decision by the Yavapai court is a very, very welcome and strong and correct decision.